Has this ever happened to you? You need to sign a contract for some reason or the other, and you get the contract in your hands, but you have no idea what to look for. Well, today I want to talk about 9 requirements that you need to check for and make sure are in place when you sign the contract. Let's get started. Contracts are an everyday part of our lives. Regardless of what we do, we enter into contracts. Whether it's buying groceries or buying a house, or negotiating an employment contract or negotiating a multi-million-dollar deal, you're entering into contracts. Regardless of how simple or complex the transaction, the building blocks of any contract are essentially the same. So let's discuss the 9 fundamental requirements that you must look at when entering into a contract. The first requirement that must be satisfied is that there must be a clear, understandable and valid offer made. For example, if I walk into a shop and offer to buy a loaf of bread at the price marked on the shelf, then I am making an offer, because I have indicated my intentions very clearly to the shop owner by offering to buy the goods at a specific price. Now, the price indicated on the shelf will not qualify as an offer, but will only be considered an invitation to treat. Most advertisements are considered invitations to treat and not offers. That is, they are considered invitations to the buyer to come forward and make an offer to the seller to buy the goods at that price. So whether it's on TV, newspapers or any digital platform, the sellers will not be bound by the prices that they indicate on the advertisements because they are not considered offers. Now, after a valid offer has been made, it can be rejected, it can lapse, it can be revoked, or it can be accepted. The second requirement that must be there in any contract is that the offer that has been validly made must be accepted by the other party. This acceptance must be unqualified and absolute and must be communicated to the other party. It's very important that you accept the exact offer that has been made. If you continue to negotiate, then the original offer will be rejected and a new counter offer will be made by you. For example, if someone offers to sell me their used car for $100 and I negotiate and I offer to buy it at $90 instead, then the original offer to sell me the car at $100 will be rejected and a new counter offer to buy the car at $90 will be created. So I cannot go back and accept the original offer at a later date because it has already been rejected. Now, the third requirement that needs to be satisfied is that there must be valid consideration. In addition to there being an agreement between the parties based on the offer and acceptance, there is a requirement that value must pass between the parties for there to be a valid contract. That is, both parties must provide and receive something of value. This could be money or money's worth, but there is no requirement for the consideration to be adequate. That is, the parties are free to determine what amounts to value for each party. Now, the fourth requirement is that we must ensure that the parties that are entering into the contract have the right to enter into that contract. Usually, human beings are considered natural persons who have the right to enter into contracts, and companies are considered non-natural entities who have the right to enter into contracts. But there are groups of people who lack the capacity to enter into contracts. Usually minors and those who are found to be mentally unsound do not have the capacity to enter into contracts. Further, those people who are intoxicated so as to not know the seriousness of their actions lack the capacity to enter into contracts. The fifth requirement is that you must make sure that the contract that you're trying to enter into is not illegal in that country. This would obviously vary from country to country. For example, a contract to sell marijuana would be legal in some countries but illegal in others. So make sure that the contract that you are trying to enter into is legal in that country. The next requirement you need to consider is the form that your contract takes. Traditionally, you can enter into any contract in writing or orally. However, sometimes the law requires some types of contracts to be created in a particular format. For example, a contract for the sale of a land would usually need to be in writing because the law requires for that kind of contract to be done in writing. The seventh requirement that needs to be considered when creating a contract is the terms of the contract. This is where the rights and duties of all the parties will be very clearly stated. These terms can be express terms as well as implied terms. The express terms of a contract are the terms that are clearly discussed between the parties at the outset and become part of the contract because the parties agree on them. The implied terms, on the other hand, are the terms that are brought into the contract because the law automatically brings those terms into the contract. For example, if you enter into a sale of goods, The law automatically imposes a requirement of merchantable quality. That means the seller must make sure the goods are of a particular standard when the goods are sold, regardless of whether the parties expressly discuss this or not. Another important term that you need to look at are exclusion clauses. These clauses allow the contracting parties to exclude liability for their actions. A good example of an exemption clause is a sign that is placed at the entrance to the parking lot which says that the parking lot is not responsible for any damage to your property while you have parked your car inside. Now, the law fortunately does not look very kindly towards these exemption clauses and have interpreted them very restrictively. There are of course many more standard terms that you find in a contract, but I won't go into detail on those terms in this video. But if you are interested in learning more about these kind of terms, let me know and I can do a separate episode on it. And make sure you've subscribed to the channel so you don't miss new episodes as they come out. The eighth requirement you need to look at when entering into a contract is the jurisdiction and choice of law clauses. Now, this is very important when you're dealing with contracts which are cross-border transactions. They deal with the issue of what forum has the right to resolve a dispute if one were to arise between the parties, and what law should be used to resolve that dispute. If this is not specified, especially in a cross-border transaction, then there is a very complicated series of conflict of law rules that need to be considered to find out which country has the jurisdiction to hear the case and what law must be used to resolve the dispute. The final requirement you need to look at when entering into a contract is how the contract can be terminated. Now, there are numerous ways the contract can be terminated, but the most obvious one is when the parties have completed their obligations to each other. But there are other instances where a contract can be terminated. It can be terminated by operation of law, it can be terminated by an event of frustration, it can be terminated because of a breach of the contract, or it can be terminated because the parties agree to terminate the contract. So it's probably wise to decide how and when the contract can be terminated at the time of entering into the contract. Those are the 9 fundamental requirements you need to consider when entering into any contract. Anyway, that's been it for this video. Hopefully you found this video useful. If you did, please do consider liking this video and subscribing to the channel. I'll see you in the next episode. Take care. Bye.